everyone, this is the Law Raven. I'm actually going to talk to you about one of our previous articles. It's titled Why People Lose Cases. This speaks to a majority of people who tend to assume that if they avoid court papers, they actually stand a chance of frustrating the case, or the case never goes anywhere, which is not true. So I'm just going to address a few points on why people lose cases. The first being that people lose cases because they avoid meeting with court messengers when they are called to come and collect court documents. If a messenger, either from court or from a law firm, calls you to say, I have your writ of summons, or I have some papers from court which I'm supposed to serve on you, you're not supposed to decline to meet with them or make an arrangement to see them and collect your papers. There's nothing wrong with collecting the papers. It doesn't mean you are admitting any guilt. It simply means you accept the documents and you familiarize yourself with the nature of the case that's been brought against you. Failure to collect court documents doesn't frustrate the case. The case will still go on even without your input, even without your response. Why do I say that? Because all the rules of court allow for the plaintiff, the complainant, to find alternative ways to serve you. And one of those alternative ways is to publish the writ of summons or the application that they meant to serve you with personally. They can actually advertise it on a local newspaper, and that will be sufficient service, because it is assumed that even if you refuse to accept court papers, you do read newspapers, or people who know you read newspapers. So they're likely to see the documents, they're likely to see the publication and notify you. Okay, so the second thing that people do wrong that causes them to lose cases is they refuse to accept court documents. And that is for those who actually are found at home by the court messenger or the law firm messenger. When you're served with court papers, do not refuse to accept them. It's the same way as the first point. Don't avoid meeting with them if they call, but also don't refuse to accept court process. It doesn't change anything for you, but it gets worse from there if you refuse to accept court process. So accept the documents. Usually you are asked to sign for them. At the back of the document, just sign to acknowledge that you have indeed received the papers. So there's nothing wrong with doing that, because if you refuse, the messenger is entitled to drop the papers on your lap and walk away. That is sufficient. It's enough service to, before the courts, you've actually received the papers. Whether you read them or you don't, it doesn't change how the case will wind up. And usually it's with judgment in favor of the party who's actually suing you. So your side of the story may never be heard. The third cause of massive loss in cases is failure to attend court. If you are called upon to appear before court, make sure you do so. Get to court on time. 8 o'clock, be at court. Most courts start at 8:30. Some of them start at 8 o'clock. So you are safe if you are there at 8 o'clock. Be there on time. Find out where your case will be heard. Sit in that court. Wait until your case is called. Then when it's called, move forward and introduce yourself to the court. If you fail to attend and only one party attends, regardless of whether it's the defendant or the plaintiff, whoever attends court is entitled to ask for judgment in their favor. If they ask for a dismissal, the case will be dismissed. If they ask for final judgment, that is to say, an award of what they were initially asking the court to do, they will be granted that order, whatever favors them, because they actually made the time and the effort to attend court, whereas you failed to attend. And that loss is by default. It means you actually haven't been heard. Only one side of the story was heard and yours wasn't heard. So that's how some people actually lose cases. It's nothing to do with the merits. It has nothing to do with your version of what happened. It's a technical point, and people win cases in that way sometimes. Another point, for litigation in Botswana, general litigation, there's a point where parties are expected to meet and compile a report. It's called a case management conference. Refusal to participate in a case management conference automatically entitles the other party to apply for final judgment or for dismissal, depending on which side of the case they stand on. Therefore, when you are invited to a case management conference, or when you're supposed to invite the other party for a case management conference, and you refuse to meet with them to have that settlement meeting, because the point is the case management conference is meant for the parties to explore a possibility of an out-of-court settlement and to avoid trial altogether. So it sort of calls for parties to be civil towards one another, and this is why people tend to engage legal representatives for their cases, because they are trying to maintain an emotional distance from the other party. If you have to represent yourself, there's always a possibility that your emotions will be roused. It provokes a lot of emotions in people, and because they get emotional, they miss the point of the meeting. So when you're called for a case management conference, attend. You lose nothing by attending or participating. You go there and you find out things are not, whatever they're offering doesn't work for you, you can walk away. But at least you participated and you indicated where you stand on the case. Then the case will still proceed to trial. So the fourth point is that you have a bad case. You have no prospects. You have no evidence. There's nothing to support your claim at all. In that case, there's really no need to sue in the first place. So abandon ship, abandon it. Fifth point, timing. Why people lose cases? One of the reasons is that people have bad timing. That is to say, you sue too late. If you file your lawsuit, there are timelines for every institution or for every lawsuit. If you decide to sue your bank, most banks have written contracts with their clients. So for example, if you decide to sue your bank, there's a time limit on suing your bank, and that is 6 years. If you have a contract with your bank and you fail to, or they fail to honor their obligations to you, you're supposed to sue them within a period of 6 years at most, and that's the maximum. If you go beyond 6 and you decide to sue them 8 years later, then you won't be able to do that. Your case will automatically be dismissed, not on the merits, but simply because the timing was off or the timing was wrong, you were too late. If you institute legal proceedings against local authorities, that is your council, that is the land board or other institutions of government, you would come to realize, especially the ones I just mentioned, you actually have 2 years. It's a short window period. Within those 2 years, you're supposed to file your claim if you have one. And if you take too long, by the time you circle back and decide this case should be a lawsuit, you're out of time. So it's a loss. It's a case not worth filing in the first place. It's just bad timing. And finally, refer to our article. I just provided the link on this video to an elaborate description of the timing for every institution of government that you decide to take legal action against. That helps shed light on why people lose cases. For every institution, there's timing. For every entity, for every organization or every department, there's timing. For criminal cases, there's also timing. That is 20 years actually. Criminal cases take up to 20 years. If you are not prosecuted within 20 years, then the state can bring action against you, well, except for murder. So just go through the article, see if it applies in your case. You may find you're actually too late to file any claims. Thanks for watching again.